All attendees are in listen-only mode.
Good afternoon, everyone, and thank you for attending today's free webinar, H1B and L1 Compliance for Human Resources. My name is Joseph Shepard, and I'm going to be walking you through today's presentation. At first, I'd like to let everyone know, if you have any questions, to please use your typing feature with the GoToWebinar software, and I will address questions. I'll try to work them in as they come in if I can do so. Otherwise, we'll address them at the end. If I don't get to your particular question, we will, either do it in our next webinar, or you could follow up via email to ask. And for those of you who already provided some questions ahead of time, thank you very much. And as a matter of fact, the majority of them will be addressed in today's webinar already. To give you a brief overview of what we're going to be talking about today in the order in which it will appear, H1B and LCA compliance and the public disclosure file, the public access file as it is also known. What are the requirements? What are the mechanics? How does it work? Including what happens when there's changes in the circumstances during the course of H1B employment, as well as what happens at the end of H1B employment. Then we'll move on to L1 compliance briefly. I don't want to spend as much time on that as I do H1B, since there's been more changes recently in the H1B context. And lastly, we will go through what to expect and how to prepare for an FDNS site visit from USCIS. These are now being administered to H1Bs and L1As, particularly extensions, usually a couple months afterwards, but we'll get into that as we go through. Our first topic, like I said, will be H1B and LCA compliance. As this title of the webinar suggests, this is H1B and LCA compliance from the perspective of the employer, particularly how can what's required, especially by the human resources individuals or department who will be actually maintaining these documents and ensuring that they are up to date and compliant with all the rules and requirements. To get a sense of what's required in the public disclosure file and what is required in the LCA process, just to give you a very basic overview for those of you who may not be familiar with the process. One of the first steps and one of the critical elements of an H-1B specialty occupation worker visa petition for someone is a certified LCA, labor condition application, which is filed with the Department of Labor and then certified, and then included, a copy of which is included in the H-1B petition. There's a few attestations that an employer must make prior to submitting the LCA, and that's what we're going to talk about first. The LCA, or labor condition application attestations. These are, the first 5 here are the most important for most employers. The number 6 and 7 are the additional attestations that apply to employers who are either willful violators or are H-1B dependent, quote unquote, and I'll talk about what that means later on. But first, that the H-1B employee will be paid the required wage. What's a required wage? Great question, glad you asked. It's the greater of the actual wage or the prevailing wage. And that the employee will get the same benefits that U.S. workers get. The same working conditions will be provided for U.S. workers as the foreign employee, and the employment of the H-1B worker will not adversely impact the conditions of similarly situated U.S. workers. Also, there has to be no strike or lockout going on at the place of employment, and the H-1B employer must provide notice of filing the LCA, and that is done in one of 2 ways. If there is a controlling labor organization for that position, notice is provided to the union representative. If there is no labor organization covering that position, then notice is provided by posting either 2 of the LCAs or 2 notices of filing which contain the essential elements of the LCAs, in 2 different conspicuous locations in the workplace for 10 consecutive business days. Once they're up on the first day, you can file the LCA, but you can't, or once notice is provided to the union rep, you can file the LCA. But if you're doing the workplace postings, once they're up on that first day, you may submit the LCA as long as you continue to post, and on the 11th business day, you can take them down and make the appropriate memos in the public disclosure file with them for the dates and places where they were posted. Now, that notice of filing is important later on, and if I don't cover it, please feel free to jump in and ask a question about it, for any changes in worksite locations in the same metropolitan statistical area or geographic area, regular commuting distance. However, there's a different set of requirements for any changes in worksite locations outside of one of those areas. And lastly, that the employer has determined whether or not they are in fact a willful violator or a dependent employer. So I mentioned that once the LCA is, you may file the LCA once the notices have been complete and the employer, makes these attestations that they'll be in compliance with all these requirements. The public disclosure file then must be made available within 1 working day after submitting the LCA. The contents of the public disclosure file or public access file are as follows. Obviously, you can't have it available once once you submit the LCA to the Department of Labor, because it's not going to be the original signed and certified version. Due to recent changes in USCIS requirements, they now interpret filing the LCA in a number of different ways other than this to mean filing the certified LCA with USCIS. Nonetheless, the most conservative approach and best practices is to get the public disclosure file in place ahead of time, and as soon as the certified LCA is available, inserting it therein. The actual wage memo. It is a description of how the employer reached the determination of what the actual wage is. Like I said, the employer must promise to pay the actual or prevailing, whichever is higher. That's the required wage. So, well, what is the actual wage? Well, great question. Glad you asked again. We will get into it in a bit. Evidence of or documentation of the prevailing wage source information. In most cases, unless an employer is using a private wage survey, in most cases this is the Department of Labor's online OFLC online data center, Office of Foreign Labor Certification web database of the various prevailing wages in different geographical areas or metropolitan statistical areas or counties, depending on how it's organized in that area. Then evidence of satisfying the notice requirements. So this is the actual notices that were posted or a copy of the union notification if that was sent. In addition, for those original notices, sometimes things may get lost in the shuffle or something similar, but to make it easy, we, in our public disclosure file samples we send with draft LCAs to our clients, we include a sample memo that can be used to confirm the notices of posting, and then that memo, once completed and signed to factual accuracy, is put into the public disclosure file with those actual notices once those notices are taken down. Then a description or summary of the benefits offered to all similarly situated employees. For example, if the person is a computer programmer in Office A, the summary of the benefits offered to all computer programmers in Office A or similar occupations or positions. If there has been any changes in corporate structure, which we will get into also, a list of the affected LCAs and the actual wage descriptions for the continued viability of those cases. I'll actually give you some more information about that in a bit if that sounds confusing. And then if the employer is using a single employer calculation for purposes of figuring out if they're H-1B dependent or not, a list of all the U.S. entities included in that calculation of single employer. I'll get into the calculations in a bit as well. Most employers are not affected by this, but some are. If an H-1B dependent or willful violator is the case, then in the public disclosure file, you must also list the exempt H-1Bs, any of the exempted H-1Bs from that calculation, and then a summary of the recruitment methods of U.S. workers completed if necessary. As you might surmise from that, the consequences of becoming a willful violator or H-1B dependent are much more rigorous than the otherwise as is otherwise required in the H-1B program. I'm not going to cover in particular all of the in great detail all of the LCA attestations, but I think one that is a frequently inquired about is what is the required wage calculation? What does that really mean? How do you determine what the required wage is? How do you determine what the actual wage is? Well, here we go. The actual wage is the wage rate that the employer has paid or will pay employees in the same or similar occupation at that place of employment. So again, that would be computer programmers in Office A, also maybe software developers if there's some overlap there. What is the wage rate paid to those employees? So, for example, and that may explain why you see on our questionnaires for each new H-1B employee, what's the wage rate? What's the wage range of similarly situated workers already? And that may vary from, let's say just for example, 30,000 all the way up to 120,000. Well, then we go down further. Well, what is this? Who's actually has similar credentials to this person, similar experience and qualifications? Is this an entry-level person? So then the actual wage calculation would focus on the entry-level people in that same or similar occupation. Or if it's a very senior person, it would be in comparison to those. And so that's why that information is requested at the outset, because it helps us help you determine what the actual wage actually is. You can go in further detail to parse out what the actual wage is, down to any other legitimate business factors, that can be, reasonably necessary to determine this. So their education, their job responsibility and function, any particular specialized knowledge they have or special skill that they have. Whenever there's not any other employees already employed by the employer, same or similar occupation or positions, you can actually determine what the actual wage is in a very simple fashion. What are you going to pay this person? What's the offered wage? So let's say that you're hiring for the first time a market research analyst, and you don't have any other, and you haven't had any market research analysts or similar types of positions on staff as of yet in history. And you want to pay this person $25,000 a year. Well, that's the actual wage. That's the wage offer. So you're not done there yet, though, because the required wage is the higher of the actual or the prevailing. So if the actual wage is 25, but according to, say, the Department of Labor OFLC Online Data Center in your geographic area, entry-level market research analysts make 35. Well, then 35 is your required wage because the prevailing wage is higher than the actual. A prevailing wage is, it can be determined either by the OFLC Online Data Center or a private wage survey. If you do private wage surveys, and we do occasionally do these for certain employers, especially in cases where there is no wage survey data for that geographic area. Maybe this is a far off and remote location that doesn't see a lot of, say, chief executive officers or something similar in play, or biomedical research scientists in that geographic area. But it is the median or mean, depending on the source, of all similar workers in the same occupation in that geographic area. Also, importantly, too, if you're dealing with a situation where you have a labor organization covering the position, in that geographic location, the prevailing wage is governed by or rather a collective bargaining agreement. The prevailing wage is actually governed by that collective bargaining agreement, as opposed to the OFLC Online Data Center. The description of the various wage levels as calculated, or rather as specified by the Department of Labor, are levels 1 through 4. And so depending on what the actual minimum requirements are, this may come into play whenever you're determining which wage level to ascribe to a particular position. The H-1B process in determining these wage levels and occupational categories is not like the PERM labor certification application process, which is a green card process. It's much more involved, and the Department of Labor makes the determination of what the specific wage level is and what the occupational category is based on what you provide. You can kind of make an argument for it there, but they're the decision maker. In the H-1B context, it's up to the H-1B employer to make the call of what's the appropriate occupational category, what's the appropriate wage level. The Department of Labor reviews on the labor condition application, LCA, for H-1B purposes. They review this for sufficiency. They're not going to go very deep into, they don't have all the information about the job duties, but they do have the title, and they have the, presumably the FEIN and NAICS code of the employer, and can make a determination if something is completely out of whack, right? So if it's like a senior software developer and you chose the occupational category of chefs, executive chefs or something like that, that would be something that they would likely say, this is clear error, we're not approving this. USCIS as of late has been trying to assert jurisdiction, anecdotally of course, but we have seen some RFEs similar to this, where the USCIS tries to say, well, actually we think that it should be this occupational category. They don't have jurisdiction to do that, and all the RFEs that we've seen on this issue have been ultimately approved, but nonetheless that may be an upcoming trend in the future. So just be sure that whenever you're determining the appropriate occupational category and wage level for your LCA and prevailing wage determinations, that you're doing so as soundly and as accurately as you can. Also, as of note, on the OFLC Online Data Center, there are a different set of wage rates set aside, or ACWIA, ACWIA wages set aside for institutions of higher education and similar entities. That is different from the all industry database. So if you are working in one of those types of employers, or working for one of those types of employers, or working with them, please be sure that you're using the correct wage database. So like I said, the required wage is the higher of the actual or prevailing, and the employer must promise to pay at or above that amount. So, what does that really mean? Well, it is the gross. So it has to be the gross salary. If it's a full-time employee and the required wage rate is $64,000, then the gross salary, annual salary, would be $64,000. You're allowed to have authorized deductions like that. You have to pay the appropriate taxes for employees anyway, W-2, but all of these things are appropriately deducted, and so even if their net is, say, 45 after all the taxes, etc., but the gross is 64, that would meet the required wage. Bonuses, if there's any bonuses that are not guaranteed, right? So if it's a performance bonus or something similar, then that if it's performance based, or if it's conditional upon something like the employer making X amount a year or the employee contributing Y that year, that may not be enough. That may not be sufficient. If their W-2 at the end of the year doesn't clearly show the required wage, then that's an issue. So the safest bet is to have the minimum gross salary, the wage rate paid per pay cycle, to meet that prorated amount for the annual required wage. Pardon me. Okay, the other subsets of this attestation is that the employee will offer benefits and eligibility for benefits to H-1B workers just the same as to U.S. workers. So what does this really mean? I think that you have to really come at this from a perspective of good faith. You have to offer this benefits package to them. They don't have to accept it, and if they don't, just make sure to document that. But you do have to offer these types of benefits. As of a note, if the employee is, say, transferring from, or rather used to be employed by another office of the company from abroad, but for whatever reason didn't qualify for, or it wasn't even attempted to do an intercompany transferee in L, that person, say, is coming into the U.S. in H-1B status, but they'll continue to get benefits from their home country. That's called home country benefits, and that's permissible, and that just needs to be documented. And I'll show you a sample of what the public disclosure file in particular would look like to that end to make sure that the company's in compliance with this. First, here's a sample from a public disclosure file for the actual wage memo. I mentioned this prior of that the company has to document that how do they calculate the actual wage, what's their system for doing so, what was the end result. This would be a sample, if completed to factual accuracy, would be sufficient for the public disclosure file. We have determined based on the criteria above, and those criteria of course need to be accurate, that the position of blank in our Los Angeles offices for employee number blank, and that employee number, so to speak, for these purposes is the LCA number itself, to be 90,000 per year to 110,000 per year. Individual employees may be paid more or less than this based on such factors. Whenever you do a range like this, that may be because, let's say that it's a marketing manager. I'm going to use a lot of marketing examples today, I guess. That perhaps there's two other marketing managers that are working on maybe different campaigns in that same office, and they have about the same qualifications, but for whatever reason, including negotiation of salary, which it can be a legitimate factor in determining this. One makes 90, one makes 110. This person is going to get 100 is the actual wage. So you could use this sliding scale for the actual wage determination. The documentation of fringe benefits. So if there's any differentiation, explain why. As you saw previously, there shouldn't be any differentiation. If there is, maybe because the person declined those benefits, would be something where you would put in that line above and or. And then below you see the and or, they're going to be doing this home country benefits scheme. All that is permissible. We suggest that individuals, if you have a handbook or an explanation or information about the benefits, to include that information and or booklet in the actual public disclosure file as well. One thing I wanted to mention is no, that's actually what I wanted to mention. Perfect. The prevailing wage source information. So it's either you did an independent authoritative source. For your knowledge, both a private wage survey and the OFLC online data center would satisfy this independent authoritative source methodology. And so what we do whenever we send our clients the draft LCA documents with the sample public disclosure file, the sample notice of filings for postings, and the other documents, we include a copy of the prevailing wage source information, a printout from the OFLC online data center, which then can be put behind this memo and inserted into the public disclosure file. Just to circle back to what the LCA attestations were, what the employer must promise before they can submit the LCA to the Department of Labor. That was number one. That's what we talked about. The same working conditions, they will not adversely impact any similarly situated U.S. workers, that there's no strike or lockout, that the notice has been posted or notice has been given, and the employer has determined the status as to whether or not they are a willful violator or dependent employer. These are the, I wanted to show you this again because I wanted to jump into a quick discussion of what a dependent employer is and what a willful violator is, and then go over what does that actually mean in terms of what you have to do. A willful violator is it's if you've ever had a determination, a finding or an order, or something similar from the DOL or the DOJ, that the employer committed a willful failure or misrepresentation of a material fact during the preceding 5 years of that LCA. That LCA meaning that you're about to file. So let's say 2 years ago, the employer that you're working for did have some, DOL or DOJ action or decision against them about a willful failure to comply with the X, Y, and Z with the LCAs. That was within the 5 years of right now. So technically, yes, you would be a willful violator, you being the employer as a representative of the employer. The employer is a willful violator, so that would be would be a box to check and additional attestations to make. So these calculations, like I said, are done at the time that you're filing an LCA. So if you're a willful violator, it doesn't mean that you violated this LCA. It means that sometime in the past 5 years, there's been a finding against the employer regarding other LCAs, and so that carries forward. That's one of the penalties, and that's why we like to stress and have webinars like this for ensuring compliance to the best of the employer's ability. H1B dependent employers. This is a really fun calculation, and in some industries this can become an issue more than others. If an employer has 1 to 25 full-time equivalent employees, and what I mean by full-time equivalent, there's different calculations you can get to determine full-time equivalency. For example, if you have 20 part-times that each work 20 hours a week, that's an easy one because you could 2-to-1 ratio for part-time to full-time. That's a quite simple calculation, and so you would have 10 full-time equivalent employees of those 20 part-time, 20 hours a week, based on 40 hours a week. So employers who have 1 to 25 full-time equivalent employees in the U.S. And they have more than 7, so 7 you're okay, but more than 7 not okay. If they have more than 7 in that situation, then they would be an H-1B dependent employer. That calculation is done, like I said, at the time you're filing a new LCA. So you do the calculation, and that's why our questionnaires ask, how many H's do you have? How many L's do you have? The L's is for another reason, but how many H's do you have right now? 26 to 50 full-time equivalent. If you have more than 12 H-1Bs at that time, then you are H-1B dependent. If you have 12, you're okay, but more than 12, not okay. And then here's where it gets ridiculous. If you get, if you're at 51 or more full-time equivalent employees, if you have more than, 15% or more of them are H-1Bs. So that drops down, and so employers who are larger than 50, in between a range of, it's about 50 to 70, in the high 70s, something like that, are actually can have fewer H-1B employees than employers of sizes 26 to 50. This is just how the regulations were written, unfortunately. So examples, if you have 51 full-time equivalents, and then if you have more than 7, back to a small employer kind of situation, then you would be H-1B dependent. 75 more than 11, 200 more than 29, etc. If you have questions about the calculations for your company specifically or your organization specifically, absolutely talk to your immigration counsel about it, so that you can nail it down and make sure that you're not missing anything, or maybe there's another, like I said, there are two real ways that you can perform these calculations. Also, as just a side note, whenever I mentioned the single employer method, that is if you are utilizing your subsidiaries and affiliates or parents that are in the U.S., you may, depending on the circumstances, be able to use a single employer calculation. Maybe you have another branch office in New York or San Francisco, and you're in Tulsa, and you have, say, 7 H-1B employees, or maybe you have 8, or, you have 8 H-1B employees already. None of those other offices have any. Depending on the situation, you may be able to use the single employer calculation for those purposes, but it depends. So that's why I mean that you should talk with your immigration counsel before jumping to those conclusions. What does it really mean? What are the consequences of becoming H-1B dependent or being in willful violator status because of something that happened in the past 5 years? Well, number one, you have to indicate that on the LCA. It's a box to check, but it's not just a box to check. Before you can check the box and submit, you must ensure that you're actually in compliance with all those additional attestations. Excuse me. These additional attestations, well, there's a recruiting requirement. The employer must have taken good faith steps to recruit U.S. workers for the position prior to submitting the LCA. Or the employer is prohibited from displacing any U.S. workers within a certain period of time. So, you have to look ahead and behind a certain number of days to see whether or not any U.S. workers 90 days before, 90 days after have been laid off. So you have to continuously watch this. Evidence of recruiting U.S. workers prior to submitting the LCA. All of these things are, in practical terms, to be avoided at all costs. It's not so much an analysis of, if it can be. Of course, if employers are in these situations, we can advise and work accordingly. But the additional attestations and requirements and the consequences of being H-1B dependent or a willful violator really almost make it prohibitively difficult to continue with that process, except in very limited circumstances. And that's why those provisions were built in essence, to make it extremely difficult to have an entire workforce solely of H-1B employees and no U.S. workers. So you can see through all the mire and through all the muck of this regulation, what the actual goal was of putting this all into place. However, there is an exception. If you are a willful violator and you are H-1B dependent, you would be subject to those additional attestations for this LCA that you're filing now for this new hire, unless you're filing for an exempt H-1B. So what does that mean? This is not cap exemption. This has nothing to do with H-1B cap exemption. This is whether or not this LCA and this that you're submitting for the new employee will exempt you, the employer, from these additional attestation and requirements in this case alone. If the H-1B worker is making at or above $60,000, or will make, right, that's the required wage, or has at least a master's degree or equivalent in a specialty. So if you have any questions about that, and for those of you who have worked on and done LCAs in the past, you may have seen this on the actual LCA. I think it's the page before the signature page that goes through, is this person exempt? Do they make X, Y, and Z? These questions are also asked again on the I-129. This is why, because H-1B dependent or willful violators may still be able to proceed with an additional LCA without having to go through all the additional steps if that H-1B employee is an exempt H-1B employee. And those are the two ways that they can be exempt. So I know that's a lot to digest. So if you have questions about it, of course, please contact Immigration Counsel again, who can walk you through it and or go through specifics. So we talked a lot about the public disclosure file. Well, what about the non-public documents that must be maintained? And this is also a good segue eventually to talk about the site visits. But what else does the employer have to do, right? All of those public disclosure or public access file documents must be held together. They relate to that specific LCA and that position. So you have an H-1B employee, you know, and I think I'll go through, if I didn't already, how long everything must be kept. But just briefly to go back to it, the public disclosure file must be maintained for 1 year or more beyond the last date the foreign national is employed under the LCA. So if there's H-1B termination and it's maybe terminated early, the LCA public disclosure file would need to be maintained for a year after the LCA is withdrawn, or so for example, let's say that they stopped working on it. They stopped working on that LCA last week, but you have not yet withdrawn the LCA. You're still actually liable to continue paying them until that LCA is withdrawn. So you're liable for, and this can be awarded with back damages down the line should it ever come to that. But the public disclosure file also needs to be maintained for a year until the actual termination occurs. So if you have any questions about that, let me know and I can clarify. The non-public documents must be maintained for a year or more beyond the last date they're employed under the LCA. So same as the same as the other situation, with the exception being payroll records. Those must be maintained for 3 years from the date that they're created for H-1B employees. The pay records are important in instances where there may be a site visit, for example, and they say, let me see a copy of all the payroll records for this person over the past year or the past 2 years. Well, if they ask for them past a year, and a common pitfall in all of this is not maintaining the payroll records for the 3 years from the date they're created. Everything else in the non-public file must be maintained for a year beyond the last date they were employed under the LCA. But the payroll records are higher and beyond that, so just be aware of that. If you don't have a complete copy of the H-1B petition as filed with USCIS for all of your current H-1B employees, get one. Get them. Make sure you have them. Those are important for a number of reasons. Number one, it's required to be kept on file. That's important because, say you get a site visit down the line, and the site visit inspector says, let me see X, Y, and Z, and one of those documents is the copy of the petition. If you don't have it, or if you don't even have it to be able to know who are the H-1B employees, well, then there's going to be problems, and likely there will be some consequences of that, be it a notice of intent to revoke, or a request for it later. So these are the list of documents that should be maintained, not with the public disclosure file necessarily. For privacy reasons, of course, there's a differentiation with the exception of willful violators and H-1B dependent employers. But the non-public documents are the H-1B petition as filed, the payroll records with the exception that they're maintained for longer, a memo stating the wage rate of employee and system for setting the actual wage, well, that's also in the public disclosure file. A memo confirming that the employer provided a signed and certified LCA to the employee on or before the date he or she first began working. So those of you familiar, again, with the process, especially if you work with us, we submit the LCA upon confirmation that the notices have been posted or notice has been provided to the union rep. Once the LCA is certified, the Department of Labor sends you a link where you download. You print 2 copies, you sign both, you give one to the worker on or before the date they begin working pursuant to the LCA. make a memo of it and put it in the non-public file. The other is then put into the public disclosure file. We ask you for an actual copy, a copy of the signed and certified LCA, because we can file with just a copy with USCIS. So we only ask that you print 2 of them, put one into the public disclosure file, the other is given to the H-1B worker, and a memo is put into the non-public file confirming that that has been completed. If there is documentation of any of the fringe benefits, etc., that's also into the public disclosure file. You can put it into the non-public as well. If there's more detail or more specific information that is, not readily given out, to everyone unless it's requested, for example, or the specifics of a certain policy, perhaps, can be in the non-public file. If there is any changes in corporate structure, one of the elements that was put into the public disclosure file was the list of affected LCAs. Note that the list of affected LCAs included only the affected LCA numbers and the actual wage structure or determination for them. It did not include the names of the H-1B workers associated with those LCAs. The non-public file does include this list. So for those employers who have ever gone through a change in corporate structure resulting in a new entity, say an asset purchase or something similar, and instead of all else being equal and assuming no material changes, if it can be handled in a way that only an LCA public disclosure file and non-public file, additional documentation of records in there can be met without having to file, say, 20 H-1B amendments with USCIS, are familiar with this process. And that list, that all-encompassing list for the non-public files, is key, so that if there was any question about it backdated, say you then do an H-1B extension for that one of those employees to prove that they've been maintaining status, you can use the copies of the public and non-public docs here for the corporate structure to show that yes, we actually are in fact the successor in interest to company X. If using the single employer test, the memo of calculation of that, including the dependency status, and then like I said before, if there's any H-1B dependent or willful violator issues regarding recruitment or displacements, terminations, documentation of those as well in the non-public. I was speaking about changes during employment, and this was the biggest, I believe, development in LCA H-1B compliance over the past year. In July of this year, USCIS put out its final guidance on when an amendment or new H-1B petition is required after a change in worksite location. So this is all based on the Matter of Semeo Solutions case that came out. It was one of the first precedent decisions, well, not one of the first, but one of the first in a long time precedent decisions of importance from the AAO. The decision basically said that if there's a change in the worksite location to a new geographic area that requires a new LCA to be certified, then you also must do a H-1B amendment. They call that a material change. So whenever there's a material change, and this has always been the case, you need to have a new H-1B petition, an amended petition, for example, to update USCIS with that change. Until this decision from the AAO, there was a lot of gray area. It wasn't clear. There was conflicting guidance memos, from USCIS, or rather not guidance memos, but guidance, I should say, about whether or not a change in worksite location was material enough to trigger the need to do an H-1B amendment. The most conservative guidance in the past has and continues to be a new LCA and an amended petition for changes. However, now we can be certain that if it's a change within the same metropolitan statistical area, so you, let's say, change worksite locations of the employee from your office in Venice to your office in downtown LA. Those are the same metropolitan statistical area. There's been no other changes, including your headquarters, your main office, remains in the same place. That has not changed, because if that changes, that may also trigger more of a need to do these amendments. But that specific change can be documented and accomplished through posting notice in the new worksite location, just as you did prior to filing the LCA, to advise all of the same or similarly situated workers in that occupation, in that worksite, that there is an H-1B employee that's going to be continuing here. So that once that notice is posted in the new worksite location in the same MSA, no other changes, that's fine. However, if you're adding a worksite or changing a worksite to a different city, say your headquarters is still in Venice, but you're going to transfer this person or add a worksite for, say, a year in Chicago, well, that is going to require a whole new LCA in order to include that new worksite location, and it will also require an H-1B amendment. There is a special provision of when is a worksite not a worksite, right? Or, I mean, that's kind of double speak, obviously, but when is a specific place that a person will be performing services not an actual worksite? There is something called the 30-60 day rule, and it's beyond the scope of this specific presentation because I want to focus this on, for now, the basics of H-1B compliance. If you have anyone who, say, is maybe going to locations for very little time during a year, or perhaps are in a job that's travels very frequently on casual and short-term bases, those are situations in which perhaps neither an LCA posting or an LCA plus H-1B amendment is required. As most employers who did have changes in worksite locations over the past year, who did do either new LCAs but did not do an H-1B amendment into a new metropolitan statistical area, or if they had a new LCA anyway, there's a safe harbor time allotted by this memo from USCIS on July 21st that extended it. Originally, it was only going to be until August 19th that you had to file your H-1B amendments, and USCIS would not come after you unless there's some other reason to come after you in the fine print. But they've extended this period from August 19th until January 15th, 2016. So employers, they gave a little bit more time to come into compliance with this change in their interpretation of the law and regulation. Nonetheless, all along, they've always considered material changes to require an amended H-1B petition. Now, though, they consider changes in an employee location to a new metropolitan statistical area or addition of a worksite in a new metropolitan statistical area. Because it requires a new LCA, it is material, and therefore the certified LCA must be included in the new certified LCA must be included in the H-1B amendment. I already discussed to a certain extent the requirements for changes in corporate structure. If you have any questions about this, please do ask your attorneys. A quick note about fees before we jump into the L1 and FDNS. The H-1B program, they consider the USCIS and the Department of Justice, Labor, etc. The H-1B program is employer-driven, and it is a business expense that should be borne by the employer. There are specific fees that are mandated that may not be paid by the employee, and there's no reimbursements, no transfers, no arrangements, etc. They are absolutely required to be paid by the employer, and that is the $750 or $1,500 acquia fee required for most private employers. in most situations. And the $500 fraud fee, which is paid for the first H-1B petition filed for a worker. So, if it's a company filing its first petition for a particular person, the employer must pay this $500 fee, and it's paid once, and it's not paid again unless it's a new employer. So everything else should be paid by the employer. The employee may, we don't advise it, but if the employee does pay for anything else, for example, the $325 base fee or the $1,225 premium processing fee, they could do that as long as the difference between the deduction of that from the wage that they're getting is still greater than the required wage. So let's say the required wage for your market research analyst is $50,000 for whatever reason, and the employee wants to pay for premium processing. If they're for their H-1B extension, let's say, if they're getting the required wage is $50,000, but perhaps their wage has been increasing since that initial determination. They're already making $60,000, and in the extension that there still will be some difference. The employee could pay that because the subtraction of the 1,225 from their their annual wages is still leaving their wage above the required wage. It is permissible. In most cases, though, this is not going to be the case. Best practices in most conservative, and we do take a conservative lean on these things, is that the employer should cover everything. Legal fees, by the way, should not be paid by the employee, especially if they're associated with preparing and filing the LCA. That is absolutely not something that may be paid by the employee. Excuse me. Let's take a drink of water here. What happens at the end of H-1B employment? Well, at the end of H-1B employment, or upon termination of H-1B employment, I should say, this is termination earlier. The employer is responsible for the return transportation costs of the H-1B employee back to their last residence abroad. This has been interpreted to mean one-way coach airfare. Well, what about at the end of the LCA cycle? Let's say that the assignment was for 3 years, the LCA was 3 years, and the employer declines to, chooses not to file an extension for that. At the end of that 3-year assignment, the employer does not necessarily have to cover the return transportation costs because it is not a termination earlier than the end of the LCA period. One important note also is that there's no benching. Benching can be thought of as putting an H-1B worker on unpaid leave because there's just no work available or whatever, right? That's not okay in an H-1B rules. You can't bench someone. You can't put them in an unpaid leave situation. However, they can request, and if they request, and I would say have them requested in writing, say leave under the FMLA, well then that's okay as long as they requested it and it was approved. But they have to specifically request it in writing to go into an unpaid leave situation like that. I need to take leave to care for X, Y, and Z. As HR professionals, you all most likely know this much better than I on the FMLA side of things. But nonetheless, just know that if there is any unpaid leave, it's only permissible if it's specifically requested, and I would say in writing, by the H-1B employee and specifically approved, and I would say in writing, by the employer. Keep those in the non-public file. Also, upon termination of H-1B employment earlier than the end date of the LCA, the employer is required to immediately notify USCIS. So for example, you have a situation where an H-1B employee is going to change employers. They gave you notice of that change, or perhaps you laid them off. Under a strict reading of the rules, you are in fact required to immediately notify USCIS. I put a question mark here because this is a frequently asked question, and in situations perhaps where there is going to be a termination initiated by the employer sometimes will give the employee notice, just as a professional courtesy perhaps, to allow them time to either pack up their things and leave, look for and find another H-1B employer, or give them enough time to at least change status. An H-1B employee is not, there is no grace period at the end, upon termination of an H-1B employment earlier than what was planned. There's no grace period. That's immediate, and they would have to immediately depart, or they could change status. They could file an application to change status, for example, to B2 visitor, in order to close out their affairs. I just need 30 days or 60 days to literally, sublet, sell all my furniture, ship it back, etc. And as long as that application to change status is filed, received by USCIS by the last day, so it should be timed appropriately, that will give them some time to literally be able to remain in the U.S. to close out their affairs. If you have any questions about those types of accommodations for H-1B employees that may or may not be, or rather likely will or may be terminated in the future, talk to your immigration counsel about that, because if you're willing to do that accommodation, or if that's something that is even just want to learn more about it, the attorney will be able to provide that information. Like I said prior, the employer is liable for paying the wages until that LCA is actually withdrawn, so there is even incentive for the employer to immediately notify USCIS. Also, I would like to specify about return transportation costs. If there is an early termination of H-1B employment that is initiated by the employer, so that's a calling the employee into the office and terminating them situation, as opposed to the employee terminating the H-1B employment. If the employee terminates H-1B employment, the return transportation costs are not required. I do see a question here about other types of visas. The other types of visas that this is applicable to, regarding return transportation costs, there is a similar, well, that's actually a good segue. E3 and H1B1. These are two different. H1B1 is these two are very, very similar to each other in that they are also specialty occupation visas. They also require a LCA. Note that on that last bullet point at the bottom, but it's a different LCA. It must be indicated and filed as E3, H1B1 Chile or H1B1 Singapore. These are different visas set aside specifically for nationals of these three countries. There are about 10,000 E3s available each year. I've never seen the cap be met since this was implemented. For H1B1s, the numbers set aside for these actually are subtracted from the annual amount of 65,000 regular cap H1B visas. However, they're different processes and they don't necessarily involve USCIS. The reason I say that and emphasize that is that once you have the certified LCA from the Department of Labor for your E3, your H1B1 Chile, or H1B1 Singapore, that individual worker can apply directly for the visa, the E3 visa or the H1B1 visa at the embassy or consulate abroad without having to go through USCIS. It is a much smoother and faster process for individuals. It was built in there as a, due to our, specifically with our free trade agreements with Chile and Singapore, and specifically with Australia, the history of it is a little bit more complicated, but it has to do with Australia joining the Coalition of the Willing, back in the early 2000s. And just because of the close ties between our countries. Nonetheless, there are some exceptions to which rules apply to these types of visas. For changes in corporate structure that result in a new entity, for example, where you have a successor and interest situation, like I said about the H-1Bs, that can be easily ameliorated with amending the public disclosure file and non-public file to document that change and the affected H-1Bs that have been transferred to the employee of the new entity. However, for E3s and H-1B1s, that's not the case. They cannot take advantage of that provision, and they must, in fact, have a new application and perhaps a new LCA, depending, to be able to work for these new entities. So they would have to depart the U.S., do the appropriate application before they could come back. The short-term placement rule is one of those, when is a work site location not a work site location? That does not apply to E3s and H-1B1s. They don't get to take advantage of that. Also, the H-1B portability provisions, having an H-1B employee start upon filing the H-1B change of employer as opposed to waiting for it to be approved. The E3s and the H-1B1s cannot take advantage of that. And the H-1B dependent and employer willful violator provisions just simply don't apply to E3 and H-1B1. The calculations are irrelevant. There is no limit or calculation needed for those. And as a matter of fact, whenever you're filling out an E3 or H-1B1 LCA, those questions on the LCA are locked and you can't even access them, so they will always be blank, or should always be blank for an E3 or H-1B1 LCA. Let's see if I can quickly go through any of these questions before I jump into the L's. If not, I will go into the, I will try to get them at the end, or you can follow up about them afterwards. There's a question here about what happens if we filed an LCA last year and the person was not selected for the H visa quota? What do we need to do? That is a good question. And, if you filed an LCA and it was certified by the Department of Labor, under the new Simeo Solutions regime, it has not been certified to USCIS, so USCIS is not aware of it. Therefore, the likelihood that there would be any site investigation from USCIS as a result would be, pretty much not there. However, whenever you file an LCA, you're making these attestations that you will, in fact, employ this person. But if the person never started working pursuant to that LCA, then you're not liable for paying that wage. So if you had an LCA that you filed and certified for a start date of October 1st, let's say, back in March, but that H-1B cap petition was not selected in the lottery, therefore that person has never started working pursuant to that LCA and H-1B status, then it's not technically been activated, and the person has never worked for that LCA. As a just person who likes to not leave any loose ends, I typically would like to, I would say to withdraw the LCA, but I don't think it's even necessary per se. And in fact, there's been situations I've seen where those LCAs just have not been effectively closed out. That is a great question, though, and that's one that I'm actually going to look into a little bit more. Thank you for that question, and provide a little bit of an update in the next webinar for sure. Let's see. For example, let's see. This is might be a longer question. Would an amendment be required for promotion from manufacturing quality engineer to senior quality engineer? I would say it depends on the specific job duties of the position. Are they more than, does the change put it into a new occupational category? Is the change in title only? Things of that nature. Does it require the same specialized knowledge to perform them? I think those are very specific, facts or case-specific questions that really would need to be looked on an individual basis. I can't say for certain whether it would or would not require an amendment, if it amounts to being material or not. in general, simply receiving a pay raise but no changes in job duties is not material. It does not require a amended H-1B petition. But a change in specific title alone with no other changes in job duties or functions would not be material, so on and so forth. Let's see. If there's a material change and you file an amended petition, can you extend the dates with the allowable period for an H-1B? That's a great question, because in one of the materials posted on USCIS's website recently about the process or procedures for filing these amended petitions specified, oddly, that you could not, that you would have to do an amendment only. In practice, anecdotally, in other situations, you can absolutely amend and extend at the same time. Whether or not they've changed that has yet to be seen from my perspective. But that is a great question, and I will do a little bit more research and see if anyone else here at the firm has had any trouble doing so based on the new Sumeo solutions. The premium processing fee, can that be paid? That should be paid by the employer, but can be paid by the employee as long as doing so does not bring the wage below the required wage. Can employees stay in the U.S. for as long as unpaid leave is approved? For example, employer approves unpaid leave for a new baby beyond the 12-week FMLA guidance up to 6 months or 9 months. As long as the request for unpaid leave was in writing for that full period given and it was approved by the employer, and it had to be initiated by and requested by the employee, that is permissible for H-1B purposes alone, just in the realm of U.S. immigration law H-1B program. As yes, they may remain in the U.S. If in the future you ever need to document, say they come back to work and you need to do an H-1B extension, documenting that they were maintained, and if it comes up, which it likely will in an RFE, if it's been very, very recent and you don't have a lot of pay records very recently from back to work, but evidence that literally the copy of the letter of request for the unpaid leave of absence and the letter from the employer approving it would be submitted as part of the RFE response, confirming that the person has been in fact maintaining status in the U.S. and they could remain, yes. Okay. Termination. We already went through this. We already went through that. L-1 compliance. So what does the employer have to do? What do they have to keep on file for an L-1 employee? Well, it's pretty simple. A complete copy of the L-1 petition or application as filed. So like I said in the H-1B context, if you have any H-1B employees and you don't have the copy of the petition as filed, get one. Your immigration counsel can provide you with a copy right away. For your L1s, there may be a different situation. It may not be a complete copy of the petition as filed with USCIS. It also may be a complete copy of the, or rather instead it could be a copy of the L1 application. Perhaps it was a Canadian border L submitted directly to CBP. Well, you can get a complete copy of that as well. Or maybe it was a blanket-based L application at a U.S. embassy or consulate abroad. That as well is a complete copy that you can ask for. In addition, of course, you would like to, for every foreign national employee, it's a good idea to be tracking all of their expiration dates. Your immigration counsel should be able to help you with that and organizing those things. This is outside, above, and beyond the I-9 rules and requirements. But what would be included in this complete copy of the L1 petition or application, and why do you need it? Well, in the event that there ever is a site visit, and L1As currently are experiencing site visits, you have questions that the field officer may ask to confirm that what was in fact put into the petition is in fact accurate. So what's the qualifying corporate relationship between the entities? That evidence would have been included in the underlying L1 petition. Usually includes, if it's a parent or subsidiary, corporate ownership documents, ownership certificates, stock ledgers, federal tax returns, org charts, annual reports, etc. In some cases, the L1Z blanket approval notice, etc. All these things should be maintained just so that in the event there ever is a site inspection that you'd be able to provide this. Also, it's handy, which I'll go over at the very end, about periodically reviewing your files to ensure, oh, have there been any changes lately? Are any of the material? For example, has there been a change in corporate structure that may affect the ability of these L employees to either remain here, continue working here, etc. Evidence of ongoing business activities of the entities. So this would have been included in the underlying L1 petition. What was included therein is usually a copy of the lease agreement of the U.S. entity or maybe the foreign entity, audited financial statements or annual reports, website information of companies. This is all important because, what if it's changed? If you see, during your periodic review of this, if you see, oh, look, here's the lease agreement for, oh, wait, we moved 2 years ago to a different office. Or this lease, from the foreign entity of an entity that's closed down. These are things that, if there are any changes like this, it's a good idea to check with your immigration counsel to make sure whether or not the change is material. Because just like in the H-1B context, material changes do require filing a new or amended petition. Evidence of the beneficiary's qualifications and qualifying employment abroad. This is usually, a year's worth of pay records attached to the EVL or employment verification letter from abroad, perhaps the beneficiary's transcripts or degrees, diplomas, certificates, etc. Their immigration maintenance of status documents. If it's an L1A extension, for example, necessarily included in that petition was the person's, I-94 record from their most recent entry, their pay records, showing that they were maintaining status by being employed by the L1 petitioner. L2 family members documentation in the event that it was it's an L1A extension and that it was recently filed. That's generally 3 to 4 months later is generally, it can be any time, but that's generally where we've seen the most frequency of FDNS site visits. And so that extension petition would also necessarily have included, well, not necessarily, the family members may have been abroad and, reapplied for visas there, but getting the family members' L2 documentation is also important. Why is the L2 family members documentation important? One of the considerations that occasionally comes up with USCIS, and now this is true in the H4 spouse EAD context. USCIS is, sometimes will take a look at the, all right, let me back up a little bit for the H4s. That's, I guess, a little different story. And I think I see a question about it anyway. So H4s now are eligible to apply for, in certain situations, an employment authorization document if the principal H1B spouse has an approved I-140 or is eligible for a extension past the 6-year maximum because of AC-21. That's a lot of information, but that very limited group of H4 spouses that can apply for EADs, great, fantastic. They can include it in the extension. However, prior to the enactment of H4 EADs for spouses at all, working on a EAD as an H4 spouse in another context, say they were they had one from a previous application for something, maybe asylum or maybe an old application to adjust that maybe is still pending in another context or something like that. Right, working on the EAD by the H4 spouse prior used to be, as determined by USCIS, a violation of their status. But so is perhaps if the L2 spouse or H4 spouse now, is really coming into not just a company. Their primary intent is not just to accompany their spouse, but it is perhaps to be to work in this job. Because the H4 and L2 spouse EADs are unrestricted work permits. And so of course you can work full-time and you can, it's unrestricted. But if, let's say that your H-1B principal spouse or your L-1 principal spouse is only a part-time intermittent employee in the U.S., and by part-time I mean literally, like let's just say in this extreme example, works 1 hour a week or comes for 2 hours once a month. But the L2 spouse or H4 spouse is working 40 hours a week in a full-time job and in the U.S. USCIS is taking looks at those to see if those are in fact valid. They want to make sure that the primary reason they're here is to engage, or rather is to, the primary reason is to accompany the principal spouse. Last section that we're going to talk about is the FDNS site visits. And I realize that we're running out of time, so I will go over this as quickly as possible to try to get to any of the other questions. So like I said, this has been implemented in order to ensure compliance with the programs. They've expanded from H1B to L1A specific, and at current, at least as of the last update, they've only been conducting these for petitions that have been filed as extensions. So if you did a blanket border L, this has not necessarily been added into the database from which they're randomly selecting these. So they randomly select for the petitions that will have site visits post-adjudication by zip code. You should expect during the life cycle of an H1B or L1 at some point, if it's petition-based, that there will be a site visit by FDNS at some point. The site inspectors are primarily focused on making sure that there is no fraud. That's number one, right? So they want to make sure that there's an actual physical office or workspace where the person is going to be. So, sometimes flags that may trigger one of these outside of the context of the random site inspection by zip code is, say, if during adjudication the USCIS officer Google mapped the address of the work site and it is literally a farm in the middle of a rural part of the state, as opposed to the laboratory that the person said that they would be working in, or the company said the person would be working in. Google Maps updates notwithstanding, they want to make sure that there are in fact physical spaces there. They may take photos, they may interview folks. USCIS takes the position that by signing the I-129, you are waiving your rights to object to these site visits and these inspections. Nonetheless, what to do whenever one occurs, you should have a plan in place. I would say put an action plan in place. Make sure that the security guard or receptionist or just one point person in the office will be will notify HR or the appropriate person of one of these. So and so's here, and they're saying that they are doing a from the government, they want to do an inspection. Find out what the inspection is. Make sure that that first contact person knows to ask, let me please see a copy of your ID or badge or business card, and make a scan and photocopy that, right? Because you want that for later. Have them ask them to take a seat and say, so-and-so will be right with you. Please just wait here 1 moment, or put them in a conference room. We'll be with you right in 1 moment. They should not be left alone and left to their own devices to wander around the office as they see fit. They should be accompanied at all times. In addition, if they're continuously asking questions or are doing an interview, you should have someone taking notes to make sure that none of these questions are way out of line. But more importantly, to have a record of what was said and what was answered. They will not always wait for immigration counsel to jump on. So if you have them, maybe call them into an office and say, while you're doing these interviews, we'd really like, or while we're talking, we'd like to have our counsel present telephonically. They don't always say yes. You can say, can you come back later, but they might not be happy with that. And they might just to say, you know, non-responsive, wouldn't let us do it, issued the notice of intent to revoke. So, you know, don't be obstinate with them. You know, counsel doesn't usually end up being present for these, and often, and you know, we find out after the fact, you know, maybe even days or weeks. But you know, make sure that everything is recorded and written down. I would also say, you know, if they're going to be walking around and taking photos, you know, write that down. You want to know this. They'll likely ask to see the person, the H-1B employee's workspace, to in fact ensure that there is a work site, you know, that the person actually does work there. If they're not there that day, you know, they're not here today, you know, but we'd be happy to follow up and set up a time for you to talk with them. You know, it's the kind of answer that is often, you know, often suggested for individuals when applying for the visa at the embassy or consulate abroad, or applying at CBP, or, you know, at an interview with USCIS downtown. If the officer or inspector asks for something that you don't have right away, or you're not sure, say, you know, I'm sorry, I don't have that, or I'm not sure where that is at the moment. I'm not the point person who's responsible for that. They are not in today. We'd be happy to get that for you, I'm sure, if we can arrange to send it to you afterwards. Do you have an email address where we could send it? But assuming that the point person is there, who does have all of the non-public documents in the files and would be able to produce these things for the site inspector, or the public access files for the site inspector, then that person should be the one handling the actual site visit. What I also mentioned before about, you know, asking their name, and also ask for who they're with. You know, don't necessarily assume that it's an FDNS officer. What if it is Wage and Hour, or what if it is OSHA? You know, you don't, or someone else. You don't know until you ask, and so make sure to ask and write it down. Also, make sure that that first contact person in the office actually knows as well who the H-1B, you know, potential individuals are. For example, individuals don't often go by their legal names. A site inspector may show up and say, I need to talk with, you know, Seymour, you know, so-and-so, and the person who's the first responder or first contact has no idea who that person is, because they know them as, you know, Sean. So that is something to just make sure is aware for the first contact person, so that they know, like, we don't have anyone here who works by that name. You know, what are you talking about? You want to make sure that any information or communication with the site inspector is by this person who's in charge of the actual site visit. If they're not able to actually get all the information that they wanted, they will follow up, and often do. Some site inspectors are fantastic and will be like, hey, I'm going to stop by in 3 days. I will likely want to see X, Y, and Z. And they'll use the email address used on the contact info on the I-129. And so that's another reason why we say make sure to periodically review all your cases, and make sure you have complete copies of all of them as filed, so that you are aware of and can say, like, maybe quarterly at least, review these to see if there's been any real changes. You can work with your immigration counsel to develop these kind of programs as well. We highly recommend it. And lastly, by the way, these slides will be available afterwards for download from our website, just in case you were curious. I do see at least one question about that already. And then finally, the results. If they cannot verify the information, they may follow up, and if they still can't verify it after the follow-up, they'll say not verified, and that will usually trigger a notice of intent to revoke by USCIS. For instances where companies have moved, if worksite locations have changed, and an officer shows up there and there's no one there, it's an abandoned building, or it's like an accounting firm and you are a, you know, computer programming shop, they will likely just jump straight up to not verified, assuming no amendment has been filed. Even if an amendment has been filed, however, that does not necessarily guarantee that they'll be aware of it. Perhaps, let's say it happens 2 months after the last one was approved, the last extension, an amendment is filed. They they may not know that, their systems may not be perfect. Nonetheless, that's why it's important to write everything down that happens at a site visit if you actually get the site inspector to show, and to loop in your counsel if you can, but not necessarily force the inspector to wait. And last, since we are just a little bit over, I will see if there's any other new questions I can answer right now. Otherwise, please email me at jshepard@wolfstorff.com, and I will get back to you as soon as I can, or we will address it in the next webinar on point. Let's see, certain H4 dependent spouses eligible for employment authorization. Is the H-1B employer, that's a good question. Is the H-1B employer required to pay the fee for the H-4 dependent spouses? No, that can be paid by either. And I would say that that is not necessarily the business expense. Should the employer pay that? Best practices most conservatively, probably yes. But I think that that one is a little bit more, or rather less directly a business expense. Well, that's all the time we have, folks, right now. I appreciate your attention, and I appreciate your great questions. It has been a pleasure. Have a great rest of your afternoon, and have a great rest of your year.